Namaskar, hello and welcome viewers. You're watching this special presentation of Sansad TV, Bills and Acts, where we analyze bills that impact you, acts that empower you, and programs that matter to you. I'm your host Kriti Mishra, and today the spotlight is on the Vishwas Amendment of Provisions Bill. And before the analysis, let's take a look at the highlights. The objective of the bill is to decriminalize 183 offences across 42 legislations and enhance the ease of living and doing business in India. The bill converts several fines to penalties, meaning that court prosecution is not necessary to administer punishments. Under the bill, several offences with an imprisonment term in certain acts have been decriminalised by imposing only a monetary penalty. Well, viewers, in the Union Budget of 2023, Finance Minister Namrata spoke about India taking big strides in enhancing the ease of doing business. The introduction of PAN as a single point identifier for quick regulatory approvals, unified filing process for renewal of licenses and periodic compliances was a welcome step. In continuation to that, the Vishwas Amendment of Provisions Bill was introduced in the Lok Sabha in December 2022. It also came across as a timely and affirmative step by the government, proposing to reduce the burden of compliances across 42 laws and decriminalisation of 3,400 legal provisions. The bill was referred to a joint parliamentary committee, which submitted its report on 17th of March 2023. And for deeper insights, I'm joined by an illustrious panel of guests. Joining us in the studio, Mr. Kumar, MP Rajya Sabha, he represents the BJD. We also have with us Mr. Ajay Brahme, Advocate, Supreme Court of India. And joining us through virtual platform, Mr. Saigal, Co-Chairman, CII, MSME Council. Also in the studio, we have with us young and vibrant audience. I welcome all of you to Sansad TV and thank you so much for joining us. And let's commence this discussion with the Member Parliament on our panel. Mr. Kumar, let's talk about the provisions of the bill and also the fact that you've been part of the Joint Parliamentary Committee that was scrutinizing this bill. So take us through the key provisions of the bill and the main recommendations and observations made by the Parliamentary Committee.
As you rightly observed, this is a very forward-looking bill. It's a game-changing bill, in fact. The bill essentially strives to decriminalize offences where the intent is not to defraud or the intent is not to evade the legal provisions. As you rightly said, ease of doing business is one of the key goals of the bill. If you recall, the World Economic Forum publishes its annual ease of doing business report. In 2013, India's rank was a lowly 132 out of 160 odd countries that the World Economic Forum, the World Bank ranks, which has substantially increased to 63. Again, not very flattering, but a respectable rank of 63 by 2019, when the bank last ranked the countries on ease of doing business. One of the key elements in the ranking, why India has such poor ranking, is the enforcement of contract. You know, today it's almost impossible to enforce a contract in India because our courts are pretty much choked up. We have close to 4.5 crore cases pending. That's true. Right? Almost 4 crore cases pending in our trial courts, 40 lakh cases in our high courts, almost 70,000-80,000 cases in our Supreme Court. So with this kind of backlog, no wonder our ease of doing business is pathetic. So one of the key objects of this bill was to facilitate or to further ease of doing business. Second element was to facilitate and further ease of living for our citizens. When Honorable PM assumed office in 2014, one of his key slogans was minimum government, maximum governance. And this is precisely what this bill aims to do. You know, it aims to build trust amongst the citizens, enhance ease of living, and also enhance trust-based governance. Other key element of the bill, as I mentioned, is to declog our courts. And then finally, the main essence of the bill is to decriminalize large sections of our legislation and outdated legislations. For instance, I'll give you an instance, the Indian Post Office Act of 1898. Right. You know, there are silly provisions. Another example I'll give is under our labor laws, there is a provision where if the washroom of the laborers are not whitewashed every 3 months, then the contractor could be jailed for 6 months. Can you imagine this? Yes, I do agree. I do concede that the washrooms of the laborers should be spot clean, speck clean. It should be whitewashed. Why 3 months? You do it every month. But to punish a contractor for not whitewashing the washroom, for 6 months, I think is far-fetched. Another example, if you allow me, Kriti,
please go ahead, sir. All yours.
You know, under IPC, outraging the modesty of a woman is obviously a crime, and rightly so. Then we have under the GST Act of 2017 a requirement to file your annual GST, sorry, a quarterly GSTR2 returns. Can you imagine that the punishment for not filing your quarterly GSTR2 returns is the same as the punishment for outraging the modesty of a woman under IPC? So these are some of the, very, very, I think, outdated and unnecessary provisions in our law. So this bill aims to decriminalize, as you rightly said, 23 acts and 189 compliances, cutting across 19 ministries. And in many cases, the fines also have been replaced by penalties. So that, the parties don't have to go to court. You can have an adjudicatory body, which is an executive authority, that can define and impose penalties as and when necessary. So I think this is a really good bill which the government has introduced, and I'm sad that it was not passed or at least not discussed in the parliament during the budget session as was expected. But I really hope that it will be passed during the monsoon session of the parliament. Absolutely,
sir. Let's hope that this is taken up in the next session of parliament. But you mentioned a very important point about pending cases. Mr. Brahme, now the National Judicial Data Grid says that out of the 4.3 crore cases pending in the country, 3.2 relate to the criminal proceedings, the criminal cases. Now, the fact that we have this bill in place, what will be the impact of this proposed legislation on pendency of cases in our country?
See, even under the criminal law, that is under CRPC, which is the procedural law, there is a provision called as Section 320, which provided for compounding of offences. So, in case there are parties, suppose there are two parties, affected parties, wherein two parties decide that let's call off the dispute because usually, and then they, so though they'll have to apply to the court, they'll have to file an appropriate application in that regard. And under exercising powers under Section 320, the offence will be compounded. Similarly, even in the West, they also had a concept of plea bargaining, which also has been, introduced in the country of late, and it has been practiced. It was being practiced. This bill, I actually look at as if this is actually an extension of those kind of provisions, and rightly so, because any bill, in case it's in derogation of the existing laws or especially the constitution, then that may not really, stand the test of law.
That's true.
So this is actually an extension of these provisions which were already existing. As rightly pointed out by my friend, the politician friend, there were some provisions like those which were outdated. For instance, the one related to the demonetization back in 78, etc. With the period of time, they actually lose their efficiency and relevance also. So perhaps this bill actually seeks to kind of crystallize and also identify as to which all acts are not really relevant as on today. In fact, if you were to look at it historically, that has been the situation right from Roman times. There would be forms of actions, and then as the society progresses, for instance, Information Technology Act, you could not have really fathomed at that time. So then it was introduced in 2000. So likewise, now that the society feels that business is more necessary. So earlier, in fact, what people would say was that in case you want to do business in this country, then jailed for doing business. I mean, that used to be the scenario. So now from this is a move from jailed for doing business to ease of doing business. That is something which is quite a salient feature of this act. There is, however, my friend also pointed out one Telegraph Act. There's one which I found, and certainly since it's a bill, so I think they'll discuss about it in the parliament. I think under Indian Post Office Act, there were certain offences, there were certain acts which would be deemed as offences. For instance, in case the postman opens up the courier, the postal letters. In case you want to decriminalize or in case you want to delete all these provisions, I personally believe this may not really stand the test of law. I think this will be contrary to Article 21 because, breach of privacy, it may lead to breach of privacy. So those kind of things, and I think since it's at bill stage, they'll discuss about all these things, churning will take place, and then I think they'll come up with some the final act. So these are some of the things which, in fact, I would suggest right here, to my politician friend that I think they should look into these kind of aspects.
Absolutely. Of course, we'll take your view on that. But before that, since you talked about from being jailed for doing business in India to ease of doing business in India, let's talk about that transformation. Mr. Saigal, India ranked 63 in ease of doing business as per the World Bank's annual rankings in 2020, a vast improvement from the 142nd rank in 2014. How has that translated actually on the ground, and how do you see the impact of this proposed legislation on ease of doing business in the country?
Thank you very much. I think from the business point of view, and I am more involved with the MSME sector, all these problems about compliance with complicated laws is really a major weight on any entrepreneur who's more focused on running his business and does not have a large expert staff which can support him in understanding the legal nuances. So I think the point made by Honorable Member of Parliament is very, very encouraging. And I hope that as the discussions move on, we will see that the whole approach is that we should not be looking at penalizing somebody unless there is an intent to defraud behind that move. Because for many small businesses particularly, many of these errors in compliance or in meeting a legal requirement is not due to intent. It is due to ignorance because you don't know, or a misunderstanding of the complexity of the rules which are applicable. Now, certainly in such cases, we should also see what is the result of criminalization versus imposing a fine or penalty. Absolutely. I think a fine or penalty is that you have caused a certain inconvenience by not complying with the systems and rules that have been set up. And you should be asked to compensate for that in monetary terms. So to that extent, fair enough. But if you put somebody on a criminal platform and then you declare him a criminal, you create a different set of complications. Are you trying to correct a mindset by declaring him a criminal? Like sending somebody to prison, you hope that the corrective action, it'll change his attitude to life, this way of doing business.
That's right.
I don't think in most cases that is required because, as I said, in most cases, this is just due to the difficulty of complying and not due to an intent or a mindset which asks for compliance. Now, looking at the ease of doing business, which you mentioned, Kriti, I think we see that with the ease of doing business and compliance, especially with all the IT interventions and the ability to do things online, and rules like deemed approvals in case of delays in getting the approvals, there has been far more compliance, which is evident by the number of micro and small enterprises, particularly, who have now come onto the formal platform by registering themselves on Udyam. And the reason they were not doing it earlier was that they did not want to come into the limelight or come onto somebody's record list who would then come and inspect and find minor violations like this. So I think it's a very welcome step and a game-changing step, as the Honorable MP has said.
Absolutely. And since you talked about the fact that there should be maximum governance and minimum government, but before I open the floor for the questions from our audience, so how do we distinguish the repealing and amending bill and the Jan Vishwas provisions bill?
Right. Let me first of all highlight here the fact that this was thoroughly discussed. Every aspect of the 42 acts and 189 odd compliances that were amended, that are proposed to be amended, were thoroughly discussed. And I have been part of other JPCs as well, but I must say the rigor and the robustness with which the committee discussed this bill was unprecedented. And this is probably the first bill in a couple of years where the report was submitted before time.
That's true.
So,
that's true.
So I must actually compliment my colleagues in the committee and the chair, of course.
Right.
Now I'll quickly, if you allow me, quickly respond to what my co-panelist brought in about the Post Office, Indian Post Office Act of 1898. What he, I think, hinted at was the right to privacy, because in the Indian Post Office Act of 1898, there is a provision that if the post office staff, any post office staff opens a letter or any parcel of any customer, then there is an imprisonment clause of 1 year. So that the bill proposed to be repealed. The committee discussed this. How will it impact the right to privacy? I think it spoke about Article 21, and he was referring to probably the right to privacy. So the bill, the committee has actually given its recommendation that this might conflict with the right to privacy, which is entitled, which is guaranteed to every citizen of India under Article 21. I must supplement also what Mr. Saigal said, given that he represents the apex industry body and particularly the MSMEs. You know, today the compliance burden for an MSME in this country is about 10 lakhs per annum.
Imagine.
Right? Imagine.
Yeah.
And there are about 10 changes on a daily basis. 10 changes. And our MSMEs and our citizens are supposed to keep track of all these changes and deal with it accordingly. Because ignorance of law is no excuse.
That's true.
And I think he also spoke about the criminal intent. You know, one of the fundamental principles of jurisprudence is mens rea.
Right.
Whether when you commit a crime, whether you have the criminal intent, that is what, you know, defines whether whether it's a crime or a lesser crime or not a crime. So most of our industry, they oftentimes fail to meet the compliance requirement either due to ignorance or because they are busy otherwise. They do not necessarily have any criminal intent. But just imagine if you imprison, you know, in a society like ours, in a country like ours, the societal, you know, taboo of spending a day in jail.
Absolutely.
You know, so that itself, you know, I think is so massive that I think this is why I said at the very outset that this is a very forward-looking and game-changing bill.
Absolutely.
Now, going back to your repeal amendment bill, that is largely about repealing many outdated laws.
Right.
Right. This bill is largely about Jan Vishwas bill is largely about decriminalizing major portions of our legislation.
Absolutely.
So that's the biggest difference.
Absolutely. The societal norm that you talked about, sir, I think that is of paramount importance. Right. On that note, let's take some questions from our audience here.
The non-compliance of statutory provisions by the accused company can avoid imprisonment as long as the company is able to pay the penalties. This will provide an escape mechanism for the big corporate house. But my concern is that for small and medium enterprises, as well as for budding entrepreneurs, I think this is discriminatory to them.
One of the students yes, sir. He says that this is going to provide a escape route for the big corporates, and this is discrimination for the smaller ones.
Well, I think we would leave it to the judgment of the experts who have been mandated in the provisional bill to be able to go into the offence that has been committed and decide on the level of penalty to be imposed. Now, the difference between fine and penalty is that the penalty is imposed and discussed by a panel of experts and not a legal person. So there is a practicality to it. I'm not very clear on what are the upper limits, but it should also be known that the penalty for a small offence would be small and for a larger offence would be more. I think that is what would emerge as the bill takes its final shape. So it's not necessarily an escape route. There is also all the other implication that if somebody is a habitual offender, he comes up the second time, I'm sure the expert panel would take that into account and impose a higher penalty. So, yes, you can get away once, but if you haven't learned your lesson, like you haven't done your homework, the next time around the teacher is not going to be lenient with you. So I think at the end of it, we will find that people will come into line. And I think the basic intent has to be that it should be easy for people to comply. And we should, again, as Mr. Sujit Kumar said, there should be a differentiation between those who have an intent to, again, commit the same offense, or they're committing it because they don't have the time.
Absolutely.
To that extent, the expert committee would be good in mediating between the two.
What about the regular offenders, the people who will non-comply about 5 to 10 times? Shouldn't be there certain criminal provisions to debar them?
See, as I had already stated, this provision of section 320, I presume that you are a student of law. See, for repeat offenders, you know, these kind of compounding or plea bargaining won't really help him. You also need to establish, as was rightly pointed out, the two elements, actus reus and mens rea. So in case somebody is actually repeatedly doing it, then certainly the mens rea is established, and it cannot also be presumed that he was ignorant, assuming for a moment that, you give that ignorantia judex non excusat a go by. Still, it cannot be deemed that he didn't know A. It cannot also be deemed that the person didn't have that mens rea. So, this kind of thing perhaps won't really help the repeat offender. I presume that will be the situation, that will be the kind of, scenario which an adjudicating officer will be dealing with.
All right.
And just to add a footnote to what, related to MSME, the gradations, etc. Whenever there is some kind of a penalty, it's most of the time, it's, there is some kind of a gradation. So in case there is a small offender, he cannot be, burdened with some heavy penalty. So there is always an element of proportionality in the eyes of law. So likewise, if you were to look at the jurisprudence for that matter, so the cook of Rochester couldn't be boiled to death. That was the situation. You as a law student will appreciate. So in case there is a small kind of an offense, then he cannot be given, he cannot be settled with such a huge penalty. So right. All those things will be actually examined.
As and when the bill is discussed in Parliament.
Yes.
Please go ahead, sir.
In fact, both the queries could be answered if they read the bill. If you read the bill, the draft bill, it already answers your queries. There is provision for enhanced penalty for repeat offence, and also there is a sliding scale, depending on the turnover and other aspects. So
perfect. Let's take the last question on the show.
Main motive of the bill is to remove the punishment provisions from minor offences. And you mentioned about GST R2B. And you also said that the main motive is to remove the provisions from outdated law. So, sir, how can something that is formed in 2017 be outdated as compared to IPC provisions from 1860 that were formed way back before?
So, the floor is yours.
Right. No, see, I mean, I think we are actually, confusing two different things. I give an example. I give an example of how our some of our laws or legal provisions put undue pressure on our MSMEs and our corporate sector. So this was just an example to highlight the gravity of the situation. Now, having said that, the fact that something which was drafted in 2017 and passed by the Parliament needs amendment. Forget 2017. The IBC is now seeing an annual amendment. So that talks about the quality of our drafting and the quality of the discussion that's happening in the Parliament. So I don't want to get into that, but it's happening. So forget outdated laws. Even laws as recent as 2017, as recent as 2020 are being amended. And precious time of the Parliament is wasted in discussing the provisions, So yes, I completely agree with you that when a law is drafted, whether it's a fresh bill or an amendment bill, then consultation, widespread consultation should happen. This is why I'm of the firm view.
Yes.
I'm a big proponent of every bill being sent to the standing committee or to a select committee or a JPC,
right.
So that there is wider consultation, so that you don't need to don't feel the need to amend it every 2 years. I do understand an IT Act of 2000 might require amendment in 2022-23 because technology is evolving every single year. But something like IBC, something like GST Act, if you feel the need to amend it every 3-4 years, then there is serious issue with our drafting skills and our consultation skills.
All right, and as you said that let's expect this bill to be taken up in the next session of Parliament, and then of course all these concerns would be assuaged. Well, on that note, thank you so much for joining us, Mr. Saigal, Mr. Kumar and Mr. Brahme. Well, viewers, that's all we could pack for you in this edition. Thanks for watching and stay tuned to Sansad TV. Goodbye for now from my side.